Great. Thanks, Spring, and delighted to be with you here today. I'm going to talk to you about a project that's in works, and I'm sort of responsible for half of it. I'm looking at sort of the legal implications of private standards for litigation on autonomous vehicle accidents. My colleague Rita Bazai is a AI person, is looking at what the actual standards being developed are. There are a number of standards being developed by various groups. I'm not that familiar with them. I hope to get to be at some point, but I'm sort of looking at the legal implications of what these will actually mean for liability for autonomous vehicles. So vehicle manufacturers have identified liability as a major impediment for them to implement autonomous vehicles. They said this publicly some, but I've had personal encounters of that over 3 decades where they have made that clear to me. I first came across the idea of autonomous vehicles in the mid-1990s when I was representing General Motors on a bunch of different emissions issues. And I went to the Milford Proving Ground in Michigan to meet with some of the people there. And the lawyer and engineer I was meeting with were late to the meeting because they just finished doing a run on the test track on a GM autonomous vehicle. This was in the mid-1990s. So GM had one then. I said, well, that sounds so cool. When can I buy one? And they said, it's going to be a long, long time. We have a number of problems. When you try to drive it into a garage, it goes, the closer it gets to something, the slower it gets. So it takes an hour to get into a close garage. But the number one issue, they said, is liability. We are extremely concerned with liability, that, people will take an autonomous vehicle and drive it towards a wall and think it'll stop and crash from crashing. And it probably will most times, but sometimes it won't. And we're worried about people using these cars in that kind of reckless way. We're also worried about how juries will respond. And so liability, we don't ever really see how we're going to get over that. So that was in the mid-1990s. Then I went into academia and I was approached by something called the Vehicle Infrastructure Integration Consortium, which is a group of car companies and DOE and others working on implementing connected cars. And they commissioned me to write a report for them on the potential for immunity from liability for autonomous and connected cars. And in working with the company lawyers on that, again, this issue of liability was just a huge deal breaker for them, that they weren't able to predict how juries and courts are going to respond to this technology, how often they're going to be held liable, and for how much. They recognize that, like any product they make, they'll never be perfect and there'll be accidents. And when they're at fault, that they will have to pay compensation, and they accept that. But what they couldn't get their hands on were the idea of sort of runaway verdicts and being held liable for a lot broader number of cases than they thought they might be responsible for. And so again, that was a major impediment to them. They were hoping to have some kind of congressional immunity perhaps put in place, and that's been mentioned a few times in California legislation and federal legislation, but never been really moved forward. And my 50-page report concluded it's very unlikely it would be adopted, at least preemptively, before the technology is there. I know they were also sponsoring studies on things like preemption. So they were very, very concerned, it's around 2012, 13, about liability being a major impediment to this technology. And then most recently, I'm currently the chair of a National Academy of Science committee on fuel economy and greenhouse gas emissions for light-duty vehicles from 2025 to 35. And part of our statement of task is to determine what is going to be the rollout of autonomous vehicles in the period 2025 to 35, what will be the environmental sustainability and other implications of that technology. And as part of that project for the last few years, we've gone and been able to visit all the major vehicle manufacturers in North America and Asia and Europe, and among other things, asking them about their plans for autonomous vehicles for 2025 to 35. This is under an NDA, so they give us confidential information. And again, this issue of liability is just a huge deal breaker for autonomous vehicles. That is something they have to have worked out, they think, before there'll be a major deployment. So we see all these examples then of liability hanging over these car companies as a major impediment for deploying this technology. And if in fact the technology will save lives, and there'd be no reason, I think, to deploy this technology until they can be sure it will save lives, the idea that liability will prevent something that would save lives seems very counterintuitive, because the purpose of liability is to enhance safety and to make things safer. So, this idea that it's going to actually impede safety is sort of kind of ironic. And so, the fact that vehicle manufacturers are concerned about this in some ways is very good, because we want them to be very careful and certain before they put these out on the road, either for testing or for commercial deployment, that we don't want to take people's lives more than possible level we can. We want to save lives on net. And so again, this incentive for taking due care is really good, and that's what liability is at its best. But on the other hand, it may be deterring safer products from coming out onto the market, just because the uncertainty about how courts and juries will deal with this technology is going to de-incentivize the technology. And so really they just are worried that there's just no anchor there. There's no regulation right now. There's no experience of car companies, but also of civilians who are on juries, for example, of how this technology is supposed to work, how it will work. And so they don't know, what is the likelihood of liability, both what type of accidents would they likely be held liable for? Again, recognizing that there will be some that they are responsible for, and that they need to pay pony up and pay the compensation for people who are injured, that's how our liability system works. But they're worried about other types of cases, broader liability, and they're particularly concerned about what the damages would be of things like punitive damages, which can be real company breakers if you get these, hundreds of millions or billion-dollar judgments against you for punitive damages. That really can take a bite out of a company's interest in the technology. And so they don't know what the scope of their liability is, how many cases, and what the amounts will be. It's really a wild card at this point, very hard to predict because there's nothing to really base it on. And secondly, they don't really know what would be the expectation, what would set the standard for reasonableness of due care. Obviously, they can never achieve perfection, so there will be some risk with these products when they eventually are rolled out. But what level of risk is acceptable? And again, because there is no government regulation on that, and it would be hard to have government regulation anytime soon, given the uncertainty of the technology and the changes in the technology. What would they be held accountable to? What would be the standard? And so they need some kind of anchor. So I think a couple of the cases we've seen already are sort of showing this uncertainty. The first one was one at ASU, where Spring and I are teach at, just outside of our campus, where the woman was killed by a self-driving Uber. And there's some interesting dimensions of this case. I mean, it's obviously very tragic, as as a woman who stepped out on the road in the dark. And the first question is, would a human-driven car have hit and killed the pedestrian? I think almost certainly that they would have. Ironically, my daughter's at ASU, and they said they feel much more comfortable when they step in front of an autonomous vehicle than a human driver. If it's a human driver, they won't step in front. If it's an autonomous vehicle, they'll know it stops. So that's very interesting. We're already seeing that kind of response anecdotally. But there's no way a human driver would have been able to stop and not hit her. So if I was driving, and assuming the woman would still step in front of my car, I don't know if she recognizes an autonomous car, but if she stepped in front of my car, I would have hit her as well. And unfortunately, I've already hit 2 cyclists at ASU because people are crazy there, where they basically go through red lights on bicycles and so on. Unfortunately, neither of the kids got seriously hurt, but they're completely at fault, and it's really hard driving in a campus area. And so I would have hit this woman, unfortunately, and probably killed her as well. So if we're going to hold the autonomous vehicle liable, but not a human liable, I don't think I'd be at fault legally if she stepped, jaywalked in front of me in the dark. I don't think I would have been held responsible, liable for that. But if we hold the autonomous vehicle liable, are we then creating a higher standard for the autonomous vehicle than human drivers? And then if these things are safer than human drivers, we might be deterring their deployment if we put in place this higher standard. And so this is this concern that the liability standard will deter deployment. But we also know from this case that the Uber car should have stopped. that because it had LiDAR, it detected her 6 seconds before the collision. It should have had time to stop, but this car had disabled some of the emergency braking systems in the Volvo car it was put in. And I was right around that time in the middle of talking to some other autonomous car companies who are testing in Phoenix, and off the record, at least, they said, absolutely, that car should have been able to stop. It's crazy. It killed her. There's no way it should. So, we want to hold manufacturers of our product to a reasonableness standard. This seemed to behave unreasonably, and a woman lost her life because of it. So yes, they should have been held liable. But on the other hand, then we're creating this double standard that might deter the deployment. So there's not a good answer here. There's a dilemma. And then I think this is further illustrated by the second case. This is a case in San Francisco where it was a GM Cruise autonomous vehicle that got in an accident with, I guess it was a Bolt, but operated by Cruise. It was an accident with a motorcyclist, and basically the motorcyclist slammed into the back of the autonomous vehicle. And the police report held that the motorcyclist was 100% responsible for the accident. If that was a human-driven car, that would have been the end of it. But the motorcyclist, because it was an autonomous car, it sued General Motors. And the argument is that, yes, it might have been me who was driving recklessly and I'm at fault, but this autonomous car is looking around at 360 degrees constantly. It should have seen me driving crazily, erratically behind it and stayed out of the way. And so again, imposing this higher standard on the autonomous vehicle than on a human-driven car, which again creates this double standard that might deter this. But on the other hand, it's true that these cars will often be able to see these types of things going on around them. They will have 360-degree vision, unlike us as human drivers. And maybe it should have been able to tell that motorcyclist was a danger and taken more precaution. And in fact, GM settled the case at basically everything the plaintiff's lawyers asked for. They never would have done that. No one would have done that if it's a human-driven car. So we're getting this, again, this double standard coming up. And when you put these two cases together, you're seeing this potential deterrent to the technology because of the higher standard that courts will hold it to, likely, which maybe makes sense. But there's just sort of this huge uncertainty then about what the actual standards and expectations will be. And so we know that, for example, currently with human-driven cars, vehicle manufacturers are sued very rarely for accidents. The vast majority of accidents, we all know, is caused by the human driver, and the vehicle can't be blamed for that and isn't. And so you get just a very small percentage of vehicle crashes where the vehicle manufacturer is possibly sued. But now as we go into autonomous vehicles, it's possible that we'll have fewer accidents, but the vehicle manufacturer will maybe sued in almost every accident they're in. And so here's the situation now. We have a much bigger circle. The vast majority of these are caused by the driver, and those are ones that the vehicle manufacturer just isn't going to be sued in. But now we go to a smaller circle, smaller number of accidents, but the actual number of cases the vehicle manufacturer may be sued in may actually go up. And so you have this ironic situation where a company is developing a product and deploying a product that's safer than the alternative, but it's going to get sued more. And so what's happening is their lawyers are scratching their head and say, why would we do this again? Yeah, we want to save lives, but if we're going to end up being in the red because we get sued, why should we do that? And so it then comes down to, so they ask their lawyers, how much will be sued? How often and for how much? Let us be able to do those calculations. And of course, that's where we just don't know the answer. And there's sort of two wild cards here that are causing these uncertainties. First of all, how does traditional product liability doctrine apply for autonomous vehicles? As I'll mention in a second, the way product liability works is by defining a defect. When is there going to be held to be a defect? And then secondly, how will juries perceive autonomous vehicles? Because in the United States, particularly, product liability cases are decided by juries. And they get to decide both if there is liability and secondly, how much damages there should be. So what do we know, if anything, about how juries will respond to this technology? So looking at the doctrinal issues first, how does product liability apply to these kind of crashes? There's various types of liability. And and there's various types of defects. But in a car crash, like an autonomous vehicle, almost plaintiffs' lawyers will usually plead a lot of alternative theories. But the two that really make a difference, the two that are the real heart and soul of a automobile product liability case, is strict liability, where there doesn't have to be shown to be fault, just simply a defect, and we'll talk about that in a second. And then the defect, there's three types of defects recognized in product liability: in manufacturing, that something goes wrong with that particular unit, something that doesn't get put on right, or it's faulty, or something causes a crash. That's not going to be the case in most autonomous vehicle ones. Failure to warn, possibly that could come up, but that would only apply to the driver, not to third parties, like the woman who got killed in Tempe. So that's not going to be the key thing. The key thing is a design defect, that the car was designed in a way to be unreasonably dangerous. So that's where the real heart of a product liability case against an autonomous vehicle manufacturer will be. And in trying to figure out how those doctrine and precedents will apply, I think it's important to distinguish two types of cases. One where the autonomous vehicle was the cause of the accident, and the second one where the autonomous vehicle was not the cause of the accident, but may still be held liable. So we know in most cases, in most car crashes, someone's at fault. Sometimes it's both cars or parties, but often the fault is pretty clear. Someone goes over a line, goes through a red light, fails to take precaution in turning, whatever it is, or rear ends another vehicle. The fault is very clear usually, and there's police and insurance reports on the accident, and they allocate the fault, and it's usually not that controversial. With autonomous vehicles, it should be even easier to do that because they're going to be collecting constant sets of data. And that's going to also be relevant to determining what was actually going on, who was at fault. So in most of these cases, we're going to be able to say, it was the autonomous vehicle at fault. For some reason, it didn't stop when it was supposed to. It went over the center lane. It turned, left inappropriately, and or it's the other vehicle at fault. And we'll be able to determine that pretty clearly. So, the Waymo cars here driving in Phoenix, I think they've been in something like 40 accidents. Every single one is the human driver at fault, the one who crashed into it. And they've been able to clearly establish that in all those accidents. Someone rear-ended them, someone went through a red light or whatever. Just being out there in a car, you're going to get hit by crazy drivers in Phoenix, and we've all experienced it if you drive in Phoenix. So it's pretty clear who's at fault. So when the autonomous vehicle is at fault, presumably it should be held responsible. And that would, I think, normally be the case. Technically, from a doctrinal perspective, you have to show a defect, a design defect. Why did this car, go through the red light? But when it's a clear error, under product liability law, there's this doctrine of res ipsa loquitur, which is a thing speaks for itself. The fact that the car went through a red light, the fact that the car strayed over the middle lane, the fact that it did something wrong, which will have been clearly established, is in and of itself enough to establish a defect in a motor vehicle product liability case. So there's not going to be a big burden on the plaintiff, the person who is injured or who's representing them, to show, what was wrong in the code of this electric vehicle or this autonomous vehicle. The fact that it did what it did, it was at fault for this accident, it was not supposed to do that, it is going to be held to be responsible presumptively. Now, there's two possible overrides of that, or exceptions: excuse and attribution to driver. So the excuse is, and we've seen all these scenarios of, the trolley problem and so on, of autonomous vehicles being in a situation where they have to make a choice between a worse or a better outcome. And the question is, are they excused if still harm comes about, but it's less harm than would have been the case if they did something else. And excuse is recognized in the law of tort and product liability for a number of different reasons. Basically, if what you did was to prevent a greater injury, your actions can then be excused and you are held not to be liable. And so, for example, if an autonomous car crosses the median line because a kid's running out and bangs into a car over here, it may not be held to be liable. It had an excuse for violating the law, for crossing that line, and the company could then make the argument that should excuse its actions. And That's a fact-based question. It's up to the jury to decide whether they accept that excuse or not. So it's very subjective and it's somewhat uncertain. So we're going to have, a lot of these cases where the autonomous vehicle may be in a crash, that it was technically the legal at fault, but there'll be an argument that there's an excuse. And so how will those play out with juries? Will depend on, in part, how juries perceive these vehicles. The other one, the one that's more controversial, I think, is the attribution to the driver. And we're seeing that in the Tempe Uber case. The car company, the manufacturer could say, if it's a level 2 or 3 autonomous vehicle, that, we specified that the human driver in the driver's seat needs to take over in an emergency situation, and that they should therefore have done that. And the fact that the human driver failed to do that makes them the responsible party. And so, as you probably heard, the safety driver in the Uber in the Tempe crash has been now criminally charged with an involuntary manslaughter as being held to be criminally responsible because she ultimately had the power to take over the car. Now, this is problematic because, is it realistic for someone who's operating an autonomous car to be able to do that on usually a matter of just a second or two? Usually not, probably. And so yet we've sort of seen from the history of liability involving autonomous systems, whether it's autopilot cases in planes or cruise control in cars or workplace robots, that it's basically the human operator who gets held with the responsibility, the legal responsibility, not the manufacturer of the product. And there's a great article in Madeline Ellis who basically argues the human crumple zone, that we basically are giving these human operators the legal responsibility, even in cases where they may not realistically have the power to do what the law is saying they should. And so, for example, there's an interesting report by the American Association for Justice, which is a plaintiff's lawyer organization. It used to be called American Trial Lawyers of America. They've just changed their name, but they're all the plaintiff's lawyers. And they wrote a report saying, we're very worried about this argument being made from level 2 or level 3 autonomous vehicles. It should be the manufacturer to be held responsible in an accident, not the human operator. And so, they're lobbying and arguing for that, and to give, evidence of, how hard it is for a human person where, something's going to go wrong once every, whatever 1,000 miles or so on, to have that level of attention that in a second, any second, when something goes wrong, they could immediately take control. But that's just not feasible. That's not how humans operate. And so therefore, putting the responsibility on a human operator to do that just isn't realistic. But that will still be an issue. And how that comes out will again be determined by the legal fact finder, the jury. How much weight will they give to that argument that it should have been the driver who should have taken control of the vehicle in that incident? And again, the facts will be very important. How much warning did the driver have? If it's, a real dangerous, slippery road conditions and they went on for 20 minutes and the driver didn't take control, that might be a stronger argument for this. But if it's something like the Tempe Uber crash, where it's just a matter of a couple seconds that the driver had to suddenly take control, that may not be realistic, and the jury may be sympathetic to that and hold liability for the manufacturer. So basically, there is this uncertainty, even when the autonomous vehicle is responsible for the accident. But the more troubling ones, I think, for the auto manufacturers is when they're not at fault. Normally, when a vehicle is not at fault, there's no chance the vehicle manufacturer would ever be sued. But now, in the case of autonomous vehicles, that is likely not to be the case. That the argument will be made that the autonomous vehicle should have been able to avoid the at-fault driver, that the at-fault driver went through a red light or crossed the lane, but the autonomous vehicle with all its sensors and so on should have been able to detect that and should have been programmed to take evasive actions and prevent the accident. And, there's some factual support for that, I think. I think it is possible for these cars to avoid a lot of these accidents, unlike a human-driven car. That's why they're going to be beneficial from safety. But the question is, what will be their legal responsibility in that way to avoid an accident, even when they didn't cause it? And there is sort of a precedent for this. It's somewhat different, but there's a whole doctrine called crashworthiness, where car manufacturers are held liable when their car's not crash worthy, that, their car did not cause the accident, the defect in the car did not cause the accident, but for whatever reason, a defective airbag or, an exploding gas tank or whatever it was, inadequate structural support inside the cabin, the car manufacturer gets held liable and saying, your car is defective because it did not survive this crash at the level it should have, that the people inside were put at a higher risk and indeed suffered injury because you did not adequately design your car. Even though your car did not cause the crash to occur, it was someone else who broke the law or whatever, you still have the duty to create a car that will survive that crash. And so I think that's very a good analog to what will happen with these autonomous vehicles. It's not crash worthiness, but it's avoidability, that your car should have been able to avoid that crash. And so there, though, the plaintiff's lawyer will have more of a burden, though, to establish that there was a defect, that car should have been able to avoid that crash. So how do plaintiff's lawyers show a design defect in motor vehicle crash cases where it's not obvious that the vehicle is at fault? And basically, there's three types of evidence that are used in product liability cases. One is a comparative analysis with similar vehicles. So that happens all the time in product liability cases. They'll say this particular car, is more likely to get people killed than an equivalent type model from another manufacturer. And so this becomes used all the time as sort of these comparison analysis of similar vehicles to show that yours is more vulnerable or more likely to fail than your competitors, and therefore de facto has some kind of defect, even though you may not be able to identify the specific defect. Based on its actual performance, you can show that this model by this manufacturer is poorer performer than its competitors. So that's used all the time right now in vehicle product liability cases. A second type of evidence is any kind of internal recognition of a problem. What often happens is the manufacturer will start to get reports of certain types of accidents, and people write memos and analysis and saying, what's going on here? And often will identify a shortcoming or a weakness in their own car's safety. And that becomes incredibly powerful evidence because it shows the company actually recognize there is a problem. Obviously, they don't have any self-interest in saying there's a problem. So it's not like if they said it's safe, it probably would have zero weight. But if they say it is dangerous, that becomes incredibly incriminating. And that's very strong evidence that the plaintiff's lawyers are always looking for. So they take huge amount of discovery of every email and memo and letter document they can get from the manufacturer to look for those admissions of liability, of weakness. And if they find those are very persuasive with a jury. And then the third way is they'll have an expert witness actually try to take apart look at the actual part or component of the vehicle that may have caused the accident and try to detect something wrong with it. So for example, in the Toyota accelerated cases, they actually had NASA look at this. This isn't the plaintiff's lawyer, but the government had NASA look at it. What's wrong with this accelerator? Why may it be causing these accidents or not? And so sometimes you can do an engineering analysis and discover something in the design of that particular car manufacturer's product that may be responsible. So what you have to show is a design defect, which is not complete safety, but rather that the foreseeable risk of harms posed by the product could have been reduced or avoided by the adoption of a reasonable alternative design. And so the plaintiff has the burden to show there's a reasonable alternative design, and they'll use one or more of these three types of evidence to try to show that's the case. And there's sort of two criteria, depending on which state you're in. Most are shifting to what's called a risk utility test. Does the benefits of using the product as designed outweighs the risk of harm? Could you have made a better decision without completely bankrupting the car or costing too much? So that's sort of an internal analysis. The original test and still this test in quite a few states is what's called the consumer expectation test, which is more subjective. What would a reasonable consumer expect the vehicle to do in that situation? Of course, no one knows when particularly it's an exotic technology about like a AV, what the consumer would expect. So these are both kind of blurry tests. But again, this comparative risk becomes very critical and likely will in an autonomous vehicle case. And one thing some not very legally sophisticated defenders of autonomous vehicles say is, well, look, it's safer than a human-driven car, so that should be enough in of itself. And that won't be. It's clear under tort doctrine that you can have a product that's actually saving lives, like, for example, an airbag or a vaccine, and yet if it causes injury in a particular case, you're still liable. Even though on average this is saving overall lives in society, if it had a defect that it should have been able to prevent this particular person from being injured or killed, you're still liable, even though your product overall is saving lives. So that just simply won't fly. To just say it's safer overall than a human-driven car, that may have a little bit of persuasive influence with the jury, but it's not legally relevant. What's relevant was this particular item, did it how it was designed, could it have been designed safer, either to be a reasonable alternative? That's the test. So I spent a number of years, in addition to represent GM on emissions, I did on safety as well. We represented them on the CK pickup cases. This is, I don't know if you remember this in the 90s, where the so-called exploding gas tanks, where NBC did this fake thing to show it exploded. But there was a real concern that the gas tanks were on the outside of the frame of the truck. And so the concern was in a side impact, it would get hit directly by the hitting car and potentially crack open or explode and catch on fire and kill the occupants. And indeed, the GM truck was more vulnerable to side impact crashes. It had a higher fatality rate for side impact than a Ford or a Chrysler, for example. But overall, it was actually safer in impacts. The Ford, for example, put their gas tank at the back of the car, and they were much more vulnerable to a rear hit. And so you had to have the gas tank somewhere. And our argument was, even if our cars are more vulnerable in the side impact, overall, we have to put the gas tank somewhere. And putting it like this, we make our car safer than any other truck on the road. And that argument was spectacularly unsuccessful. It just did not work with the jurors. The courts wouldn't, therefore exclude evidence from the other side based on that to give us any deference. And then the jurors just, totally disregarded that. So again, this kind of precedent causes a lot of consternation for vehicle manufacturers, that even if they can say the autonomous vehicle is safer, they're still going to be concerned about how it's going to play out. So there's a lot of uncertainty about how traditional product liability doctrine will apply in these cases, whether the AV is at fault or not, and both in when will they be held liable, and then of course for how much. So doctrinally, there's a lot of uncertainty out there, which causes a lot of stress for a company who may want to deploy that. But that's all exacerbated by concern about the jurors. So in the US product liability system, way more than any other country, we give almost all the power to juries. And they're going to determine whether there is liability, whether the design was reasonable or not, which again, as we've hopefully communicated to you, is quite a subjective decision. So it'll depend on how they think about this. They will decide how much liability, how much damages to give. And most important, they'll decide whether punitive damages are appropriate. And that's a real, company killer. And so that's a huge wild card as well. And the problem is that how juries decide cases is not simple. It's not simply a probability times consequence, like meaning the expert witnesses use. There's all kinds of other psychological and subjective aspects of that can vary very much between juries, depending on who's there, who sort of takes leadership within the 12 people in the jury room and so on. So it's very hard to predict how juries are going to deal with technologies, particularly sort of novel technologies. So this is a famous study by Paul Slovak of talking about how does the public perceive risks of technology. And again, it's not a probability times consequence like an expert or an engineer might do. There's other factors that are important to the public, whether it was a voluntary risk, how catastrophic it was, how unknown it is it a dread risk? There's all these factors that turn out to be very important to the public in terms of how they rate a risk. It's not just the probability times consequence. And so when you get something exotic like an autonomous vehicle, it's likely to be way up here in the dread unknown sector, the quadrant, which means that the public will give it greater responsibility, greater likely to be liable, like that would be our expectation, given on how they consider other types of risks. And in fact, we have seen this in polls that the public is very skeptical of this technology, even though it may end up saving a lot of lives. Right now, they're worried, and many people will not drive in one. Of course, there are people who seek out and want to drive in them, but the majority of people have a lot of concerns about these. And again, it's because of this unknown. This article by Jerry Kaplan of Stanford talks about, because it is this sort of exotic technology that they don't really understand, right? They're not going to understand, how an AI system is controlling that car. And so then when there is an accident and there's a person who's been harmed or dead before the jury, they're going to very likely attribute blame to this autonomous vehicle, regardless of what the doctrine and the facts may say or whatever. Sometimes they'll be justified, but they're probably likely going to be much more willing to extend liability than they will for a normal car or some technology they're much more familiar and comfortable with. And there's been all kinds of studies about how juries deal with risks and how they allocate damages and liability. One of the big findings is they hate uncertainty. In fact, they will give higher liability to a product that's uncertainly going to cause that risk than one that will definitely cause a risk. Even though the definitely cause the same risk should be the more dangerous product, because we definitely know it's going to definitely cause a risk, juries will give higher likelihood of both liability being determined and higher damages when the risks are uncertain. They do not like uncertainty. They're very uncomfortable with it. And going all the way back to Ellsberg's paradox, we know people don't like uncertainty. They like things to be simple, black or white. They don't like this fuzziness, I don't know what the risk is. And so when a company puts out a product that there is uncertainty about or ambiguity, there's a real red flag there that if they get in an accident, the juries are not going to be kind towards you at all. Another thing that juries don't like to see is companies monetizing and putting values on life. So this is a case I was unfortunately had a little bit of involvement with, where GM got hit with a $5 billion jury verdict. $5 billion, a lot of money, even for a company like this is in the 1990s for GM. And the reason the jury punished them, no one even died in this accident. They got seriously burned, they got seriously harmed. It's not clear GM was really at fault for the accident, but what was clear is that they had had a memo written by a young engineer that probably never even was taken into account, that looked at the cost per life save of different changes. And juries hate that. There's been a huge number of studies showing that if companies do cost-benefit analysis of people's lives, their jury and the jury sees that, they'll just absolutely punish that company. And so, autonomous car companies have to make these trade-offs. So when is it safe enough to put this on the road? And you can be sure they're making those kind of internal calculations. And when that gets turned over to the plaintiff's experts, they will spin that and tell the story to the jury in a way that they're going to get really hammered by making that sort of crude calculation of what is a human life worth in dollars. Then any type of corporate wrongdoing, and when you have large companies, you're almost always going to find some, is again something the juries go on. So we've had these 3 different cases now on Roundup, the insecticide. I do a lot of work in that area. I've done a PhD in toxicology. I think the science on Roundup is very good. It's probably by far the least toxic herbicide on the market, and it's very unlikely it causes cancer, and there's good data showing that. But that didn't matter in all 3 cases. Anywhere between the lowest was 89 million and the highest was 2 billion. The other one was 300 million. The jury just hammers Monsanto, because even if the product was safe from a scientific perspective, and the jurors don't really understand the science, what was clear is Monsanto engaged in a lot of nasty stuff. They faked studies. They supported scientists to say certain things and then denied they did it. They basically lied and connived. They may have done that to support a relatively safe product, but they still did those bad things. And there's good evidence, again, shown through discovery. And that's what the jury hammers them on. You're a bad actor. We don't care what the science says so much. We have someone dying of cancer here and you've engaged in shenanigans. We're going to punish you big time. And so they get these huge punitive damages. And, Monsanto's now been bought by Bayer. Bayer might go bankrupt because there's thousands and thousands of these cases now, and they're going for $1 billion each. They can't afford to lose these all, but because there's all these bad documents there, they very well likely will. So we could be seeing a major pharmaceutical company going bankrupt over this product. On the positive side, from the manufacturer, there is this concept of effect that if a product is beneficial, people are willing to downplay the risks. I mean, we still don't know if your cell phone causes brain cancer or not, but we get so much benefit out of it, we will go ahead and take that risk. We don't care. Driving in your car today is a very dangerous thing to do. It's one of the most dangerous things we all do, but we're willing to do that because we get a huge amount of benefit. And so these studies are showing that people view risks and benefits on a teeter-totter. And if the benefits go up, their view of the risk go down. If their view of the risk goes up, their view of the benefits go down. These things are inversely connected in people's brains. So, if a manufacturer can convince a jury that, hey, this is a product that's making things safer. It's unfortunate what happened in this particular example, but overall, this is a safer product. And if they can convince juries of that, then the jury is likely to be, weigh that benefit by reducing their view of the risk and the hazard and the responsibility. But there's a double-sided edge to that because another thing juries hate is denial of risk. And so we're seeing that right now, for example, in the Johnson & Johnson baby powder cases. I don't really understand the science on that. I've looked at it quite a bit. It's pretty uncertain whether or not this sort of asbestos-like fiber that may be in the talc powder, it's not asbestos, but it's sort of maybe like it, whether that's causing ovarian cancer in women who use baby powder. But every woman who's used baby powder gets ovarian cancer right now can bring a lawsuit and probably win many millions of dollars because the juries are just hammering Johnson & Johnson. And the problem is that Johnson & Johnson isn't saying, yeah, there could be a problem here. We're going to try to, address this and study it or whatever. Instead, they say, no, there's zero risk. There is no risk. And juries don't like that. They don't like you saying this is safe when you've got in front of them a plaintiff who's suffering and who's clearly injured and harmed, even if the causation is uncertain. And so again, this is then a two-sided sword for the vehicle manufacturers. If they make the claim, hey, this product's so safe, and then in front of the jury, there's someone who's been injured by an autonomous vehicle, this argument will actually backfire against them, and they're likely to get higher punitive damages. There's this doctrine called, this idea called betrayal aversion. When you have a product that you market as being safe, promoting safety, and then it hurts someone, jurors punish that much more than a product that would cause that same harm directly. They don't like products that are marketed as promoting safety that actually hurts somebody. And so as this article concludes, betrayal risks appear to be so psychologically intolerable that people are willing to double the risk of death from automobile crashes, fires, and diseases to avoid a small possibility of death by safety device betrayal. That again, both in our behavior outside the courtroom, but also as jurors, this doctrine, this psychological effect really punishes anyone who tries to make the claim that this is a safer product. And so we see this in the airbag cases and so on. So, if I'm a vehicle manufacturer, I'm looking at this and I don't like the way this looks. This looks very scary to me of a lot of uncertainty about the legal standard that should apply. And jurors are going to be, I think, very skeptical because this isn't just taking someone off the street and asking them about autonomous vehicles. This is now in a courtroom where someone has been killed or injured. The injury has now occurred, and they're now responsible for allocating the compensation and the punishment for that. And when that injury's occurred, it's now post hoc. It's going to be a very different situation. So, there's been a lot of talk about vehicle standards by NHTSA, by various industry things. Could that be helpful for manufacturers to have a bit more assurance and some grounding and anchoring of what their liability exposure would be? And so again, there is these various organizations, IEEE, ISO, UL, SAE are all in the process, or in some cases have now finalized standards relating to autonomous vehicle safety. And they cover different aspects. Some of them are complementary, some of them are duplicative. Again, I'm not an expert on those, but they're coming. And the question is, will those be helpful? And, standards are sort of going through an evolution. They used to be sort of technical, to use the same terms for technologies, to make things be able to connect when you plug your electricity into the wall. The UL standard makes sure that it's all the same size, or train rail gauges are the same length. So a freight car could operate on any train. Or use same testing methods for safety products or fire risk, for example. But now a lot of these standards are assuming a much more important sort of policy role of sort of a risk management. I think in part to fill the regulatory gaps we see with a lot of these new technologies, where our traditional regulators are way too slow to regulate. And so these are taking a bigger role. And so what will be the issue? What will be the impact of these in liability? And I'll just go quickly through this because we're almost out of time, but there is a lot of case law and precedent that if you comply with an industry standard, it's not an absolute shield against liability, but it can be incredibly protective, both legally, doctrinally, as well as psychologically with the jury. That these private standards, that if you can show you did your best, you complied with this private safety standard that's accepted, that is very helpful in a product liability case. Whereas if you don't comply with it, you violate it, that's used against you as a sword. And so there's, again, a lot of case law showing the impact of these private industry standards in the liability determination. And most importantly, by law in many states, you cannot get punitive damages if you comply with industry standards. So it's a complete block to any punitive damages. If you can show you comply with a relevant relevant private standard, safety standard. Whereas if you don't, you're at risk. And then a lot of other states allow it to be used as persuasive evidence against liability. Now, there are exceptions that when the standard does not protect against the risk that occurred in this case, or if you as a manufacturer are aware of other risks not covered by the standard and don't do anything about them, that exempts this protective effect. But still, these private standards could be incredibly effective. There's a lot of nuance on this that we're developing in an article, but it matters who develops the standard. It's got to be a recognized standard organization. It can't be sort of an ad hoc consortium of companies. And so the fact that it is ASI and IEEE and SAE adopting these standards will be helpful. They have to have received industry-wide support. They have to be up to date. If you can show that the standard's outdated, they don't have that effect, that they can be ignored by the jury. Are excluded from evidence. So how well will these standards do in keeping up with this fast-moving technologies? And then, we have to ask from a broader societal perspective, is this really the right gauge we should be using? I mean, these are adopted sort of by industry groups, there can be insurers at the tables, academics, but it's not like a government regulation where you get the full range of stakeholders participating in adopting these safety standards. So one question is, what are these safety standards? How acceptable from a societal perspective should they be? Because they're going to potentially have a big impact in this litigation. And so just to conclude, so there's a lot of uncertainty right now about liability for autonomous cars. Internally, this is a huge deterrent from car manufacturers developing and deploying this technology. Whether it stops them at all remains to be seen, but there's going to be a lot of pressure from the General Counsel's office not to go ahead until they have greater assurance. But maybe private standards can provide some greater stability, some greater predictability by anchoring what's expected and when there should be liability or not. But there's still questions about those standards too that has to be further thought about. So sorry to go so quick at the end, but if there's time for questions, I'm happy to take any.